Welcome to our second part of the course, the Digital Services Act, Risks, Transparency and Data Access, Mastering Europe's Digital Decade, Platforms, AI and Regulation.
In this part, we want to have a closer look at content moderation, a core process to keeping online platforms like TikTok, Booking, or X working.
Since platforms are referred to as the new governors of speech and shape what people see online, this also has a political dimension. Let's have a closer look at what forms political power can take.
For example, unilateral censorship by Tarleton Gillespie. This concept refers to the removal of culturally and historically relevant content through platforms. A good example for this unilateral censorship is the image that got known as the Napalm Girl.
Second, algorithmic opinion power. Even with deleting anything, platforms can steer public attention by ranking, recommending, and amplifying. That's opinion power, shaping what people see online and therefore what they consider salient. Natalie Hellberger argues that this steering function has clear political consequences.
And third, digital gatekeeping through private community guidelines. These function as the rules of allowed platform behavior put in place by the platforms following their understanding of what is okay and what goes too far. An example of digital gatekeeping is the definition of nudity on platforms and how much skin can be shown online.
Which brings us to the key point. The old legal dichotomy of host versus editor doesn't describe this reality well anymore. What's increasingly needed, according to Hellberger, is a model of cooperative responsibility. Platforms, users, and the state, each carrying parts of the governance burden, especially to protect public values like transparency and non-discrimination.
To frame this more systematically, we can use a platform governance lens. Robert Gover defines platform governance as something that requires understanding both technical systems and the global context in which these operate.
And Gover describes 3 governance modes.
Mode 1, self-governance. Platforms set and enforce their own rules in highly visible public spaces. But the problem is they can be black boxes and data silos. If you can't see how decisions are made, accountability becomes very difficult.
And because platforms operate across jurisdictions, for example, in the EU, there's 27 national legal systems. Platforms are constantly navigating uncertainties and differences.
Mode 2, external governance. This is where states respond with regulation. Often because self-governance is perceived as insufficient. A good example is German's NetzDG, which was kind of a predecessor of the DSA, regulating online platforms, illegal content, transparency reports, etc. A bit more about the NetzDG in a second.
Mode 3 is co-governance, a third way. Not full state control, not pure self-regulation, but hybrid accountability mechanisms that aim to introduce checks without completely restructuring the ecosystem. For example, Facebook introduced a quasi-Supreme Court, which is now called the Oversight Board, which would allow external appeal for content policy decisions, but only a few per year. Let's continue for a concrete example of external governance. Germany's Network Enforcement Act, or short NetzDG, is a national law introduced in 2017 and enforced from 2018 that pushes platforms to remove illegal content quickly, with a few-hour time frame after notification of illegal content, and with high fines for non-compliance.
The governance logic here is important. The state doesn't moderate content directly, but it provides procedural rules for platforms to do it fast.
Which is why the NetzDG is often praised as an early and forceful response to harmful content, but also criticized for overblocking risks, when platforms remove too much, too quickly, to avoid liability.
So basically a similar balancing form as in the DSA, which tries to structure more procedurally. A different governance experiment is the Oversight Board, as mentioned before, a co-governance style mechanism created by Meta to review content moderation decisions on Facebook and Instagram, which began to work in 2021.
The main point here is independent review, more transparency, and human rights-oriented frameworks. Supporters see it as a meaningful accountability step.
But there are major implications. First, a limited justification. It reviews individual content cases, not systematic issues like algorithms or broad account enforcement on the platforms.
Second, limited impact at scale. The volume of platform moderation is massive. Only a tiny number of cases can be reviewed.
Third, even where the board sets precedent, the platform relates significant control over how consistently those precedents are applied.
So it's a real innovation, but not a complete answer. Let's step back and define content moderation through a theoretical frame. A definition by Grimmelmann: content moderation is the governance mechanisms that structure participation in a community to facilitate cooperation and prevent abuse.
And the definition clearly outlines something important. Moderation is not only about taking content down, it's about designing and governing the whole participation environment.
The online community has three components: members, content, and infrastructure.
And these are different roles within its owners of infrastructure: moderators, users who create content, and the readers who consume content. Let's give this some context. A simple example: on YouTube, Google owns the infrastructure. Uploaders are users, viewers are readers, and moderators include both professional and ordinary users who flag content.
The critical complication is that roles can overlap. A creator can also be a moderator, a platform can be both rule maker and rule enforcer, and incentives can conflict.
That's why communities often need clearer separation of roles, or at least clearer procedural safeguards. This is why the DSA is so interesting.
So we bring this into the DSA context. Moderation is not just a technical practice, however automated. It is embedded in civic discourse. Balancing free expression with harm mitigation is quite tricky.
And it becomes even harder when content categories are broad, like endangering civic discourse. Broad categories can be necessary, but they can also be misused or selectively enforced.
Plus, platforms reflect value systems. They operationalize norms through policy language, interface design, enforcement priorities, and automation.
So the DSA defines content moderation as activities, whether automated or not, undertaken by providers, the platforms, that are aimed at detecting, identifying, and addressing illegal content or information incompatible with the terms and conditions.
The DSA's big move is to treat content moderation as a structured legal process, not an opaque private practice.
We distinguish ex ante measures before publication, like the upload or illegal content through algorithms, or ex post moderation after publication. And that's where the DSA situates most of its new procedural pipeline. Let's have a closer look. But first, let's hear from our expert.
Content moderation is regulated in Article 14 DSA, which contains provisions on the general terms and conditions of providers of intermediary services. It follows from this provision that providers of intermediary services, platforms in particular, are permitted to establish their own rules for communication on their platforms. This means that they are not only allowed to ban illegal content, such as content that infringes the personal rights of third parties. They may also ban lawful but harmful content if they wish to do so, for example hate speech, because they wish to foster a civilized culture of communication within their platforms. While platforms are permitted to set the rules governing communication on their services, they must meet certain requirements regarding their terms and conditions as set out in Article 14. These requirements are intended to benefit users of the services, who should be aware of what communication is permitted and what is not. Accordingly, the terms and conditions must, in particular, contain specific information on content moderation. What guidelines exist, what procedures and measures are employed by the intermediary services, including whether algorithmic or human review takes place. The terms and conditions must also be written in plain and understandable language and be accessible to everyone before they register for the service. Moreover, the application and enforcement of content moderation must be carried out carefully, objectively, and in a proportionate manner. In other words, platforms must take account of users' fundamental rights in this regard, and in particular, moderation measures must not unreasonably restrict users' freedom of expression.
Stage 1. Notification. Notice and action, Article 16. Users can report allegedly illegal content, and reporting mechanisms must be accessible and user-friendly.
Stage 2. Prioritization. Trusted flaggers. Article 22. Certified expert entities get priority handling. The idea is to improve illegal content takedown, quality and speed for high confidence notices.
Stage 3. Assessment and action. Article 17. Platforms assess legality of terms of service violations and can remove, restrict, demote, suspend, a range of interventions.
And this is where a crucial procedural safeguard comes in, the Statement of Reason database, which is a new database about all moderation decisions. We will be talking more in another video about it.
Stage 4 is redress. Articles 20 and 21. Users get internal complaint handling, out-of-court dispute settlement options, and judicial remedies, of course, remain available.
Stage 5. Documentation and transparency. Various DSA transparency obligations like before mentioned Statement of Reason database or the transparency reports, to name only some. Moderation becomes more visible to regulators, researchers, and civil society through reporting and logging moderation decisions. Now, what kinds of actions do platforms actually take? One way to organize this is, of course, content moderation techniques. Exclusion.
That means removing unwanted members or suspending user accounts.
Pricing.
Using market mechanisms to shape participation, for example, ad auction pricing or membership fees.
Organization.
That means reshaping content flow, so for example, ranking, recommendations, and visibility.
Norm setting.
Teaching and enforcing community-serving values, for example with community-based moderation like community notes. And in practice, platforms implement these through more specific techniques, like removal, blocking, demotion, demonetization, shadow banning, and so on.
The key message: not all moderation is the same. Two platforms can solve the same moderation problem with radically different governance choices. And those choices have distinct rights and accountability implications.
Let's go back to a fascinating new DSA feature. Article 17 doesn't tell platforms which technique to use. It regulates how decisions must be made, explained, and documented, regardless of the technique.
That means if a platform removes content, reduces visibility, limits monetization, or acts against an account, it must provide a clear statement of reason entry.
And that statement could include the legal or contractual basis on whether automation was used.
In other words, the DSA shifts the regulatory focus from did you choose the right outcome to Did you follow a procedure that is traceable, contestable, and aligned with the rule of law principle?
And that sets up perfectly for what comes next. How notice mechanisms are designed, what user-friendly actually means in practice, and how transparency tools like the Statement of Reasons database can enable oversight.
Thank you for watching. We hope that this session provided a good basis about what content moderation is and how the DSA shapes it.
We hope to see you again in the next video where we have an even closer look at the transparency mechanisms of the DSA.